there's also these circumstances where people come to the United States to go on vacation to like Disney World or
Mm.
whatever, right? Turns out they were pregnant, mom goes into labor early. Suddenly she's had a baby there in Orlando, and the kid now has a social security number, was wrapped in a nice 1040, onesie, and said, "All right, we'll see you when you're 18," right?
Welcome to Planning Reimagined, a podcast from the planning experts at Robin Glenn and RX Investment Partners for wealthy families and successful business owners. Hi, I'm Celeste Moya. Welcome to another episode of Planning Reimagined, where your wealth journey meets our expert insights. If you've been to Disney World, you probably rode the It's a Small World ride. And then that song was stuck in your head, what felt like forever. Yeah, me too. With the rise of the truly global citizen, for affluent individuals and families, the world really is getting smaller and more connected. But what does that mean for their estate and tax planning? Well, that's exactly what we're going to be talking about today. We're very fortunate to be joined today by two experts who work daily with global clients facing these issues. First, we have Robert Smith, a partner at Saville CPAs and Advisors, and their leader of their global advisory group. Robert helps his clients by solving their international tax problems and removing obstacles to their cross-border success. Thank you so much for joining us, Robert. We're also
Thank you so
joined.
much.
Yes, of course. We're also joined by Steve Hare, an attorney of what I'm going to call YDK, and he can say the name of the firm because it's difficult to say and I'm going to mess it up. But he practices in the areas of U.S. and international trust planning, estate planning, and probate law. And Steve has extensive experience in representing cross-border clients, advising on tax compliance, and multi-jurisdictional probate issues. I would say this is a pretty rock star lineup for the conversation we're going to have today. So thank you both so much for joining us. And of course, we're joined by Kris Stegall, our resident expert in advanced planning, who's regularly at the forefront of planning for our cross-border clients. So thank you all for joining, and let's jump right into the conversation because we definitely have a lot to cover today. I feel like we might have to have a part two of this conversation. There's so much to talk about. So everyone here today on this podcast has probably encountered a client situation in which the client was just absolutely shocked to learn that they had, without their knowledge, become a U.S. taxpayer. So let's start the discussion there, trying to understand potential tax obligations for non-U.S. citizens. So Robert, let's start with you. What tax obligations might a non-U.S. citizen face when owning property or other investments in the United States?
Thanks, Celeste. Yeah, so that's a great question, and you're right that many times clients are surprised. For those of us who are in the United States and are U.S. tax residents or citizens, we're used to, generally speaking, the worldwide taxation system of the United States. So we know that we have tax obligations all over the world. In the United States, regardless of where that income is being earned, the U.S. wants to tax it. But the flip side is not the opposite. It's not all or nothing. If you're a non-U.S. person, you still can have obligations in the United States, because if you have income from U.S. sources, or if you have assets in the United States when you die, then the U.S. tax net will extend to you, even if you are very far afield. And that can sometimes be a surprise to people. It's the same thing for U.S. people if they've got assets and investments in other countries. Countries want to tax the income coming from their country, and the U.S. is no different. And in fact, Congress is very concerned about making sure that non-resident individuals do pay their tax and that foreign corporations pay their tax for what they earn in the United States. So from an income tax perspective, when we're talking about a non-resident, we're usually looking at withholding taxes on interest income, dividends, different kinds of income streams that are coming from U.S. sources. And those will be withheld at 30%. And the taxpayer will hopefully get a tax credit in their home country to offset that and not be double taxed, but that's up to their home country. And in some cases, if a foreign taxpayer is doing business in the United States, they might be eligible for net tax rates, and they'd be taxed essentially like a U.S. person, but only on their U.S. source income, not on their worldwide income. But still, the tax net definitely extends to those non-residents. A big issue that we find with non-residents is planning for estate taxes. And I know we're going to talk a lot about that later.
Yeah, absolutely. That's another shocker. But yeah, Kris and I have definitely worked with clients where all of a sudden they have this issue and had no idea what they're gonna do or that it ever happened, right, Kris?
Yeah, I know completely. I've got quite a few interesting stories to share about that. I know, again, like you said, we're going to get to some of those estate taxes and how we planned around that. There's some fun ones out there.
Mhm.
So, Steve, how do these obligations change if they do decide to become U.S. residents?
Well, sure. Well, I think let's initially just start by separating two different issues. There's residency, which is kind of a question of income tax, and then there's domicile, which is a question of estate taxation. And it's important not to conflate those two ideas because they're two different tests and they apply to two different types of taxation under the US system. So, residency, because Robert led us out with income tax. So, let's go there first. So, when we talk about somebody becoming a US resident, usually what we're talking about is they move here or they obtain a green card or they fail the substantial presence test. So, green card, everyone kind of knows about that. It's a bit of like an immigration thing. You get married or get a job and you get a green card and then you become a US tax resident. Substantial presence test is kind of what it sounds like. You just have to be here for a substantial amount of time in any given year. Generally speaking, it's about 183 days per year, but there's this prorated substantial presence test over 3 years. And so you can actually be in the US for less than 183 days per year and still become income tax resident in that specific year. So what does that mean if you become a US tax resident for income tax purposes? Well, I think as Robert mentioned, basically your worldwide income all of a sudden becomes subject to US taxation. And so all of the pockets of income that previously were excluded from the US income tax net all of a sudden get swept up into paying US income taxation. Some of the nice things that happen if you become a US income tax resident is that some of that withholding drops off. So, and again, I don't want to go too much into the weeds of it right now, but that withholding doesn't occur, but you get taxed, at source, for example, with capital gains, or should I say, you actually have to file a regular income tax return to report those capital gains. And things like FERPTA don't apply. So if you are a non-US person and you own real estate in the US, and then you sell that real estate, there's a 15% withholding on that sale. If you become a US income taxpayer, you don't have to worry about the withholding, but you do obviously have to pay US income taxation. So it's not like you can have your cake and eat it. Just to quickly mention domicile, if I might, seems like I've introduced the topic. So that's relevant for estate and gift taxation. It's much more of a gray area. And so it's basically a test predicated on intent. It's where you intend to reside is your domicile. And so notionally, everyone is domiciled somewhere. And the question of how you determine someone's domicile turns basically on facts and circumstances in that person's life. So if somebody moves to the US, even if they have a green card, or even if they trigger the substantial presence test, it's possible they're not domiciled here. And so the facts and circumstances that can lead eventually to a domicile status can be things like where your homes are is a pretty obvious one, but where your businesses are. I've seen it happen where your dogs are, can be the trigger for some people. And so I just want to introduce that now because I want to make sure that the two ideas are kept separate, and you can have somebody who might be resident for income tax purposes, but not domiciled here for gift and estate tax purposes, or even vice versa. I've got clients that are domiciled here for gift and estate tax purposes, but they've given up their green card and they're actually not a US income taxpayer anymore.
So what I'm hearing is that IRS likes to make it really easy on us and everybody else to how to differentiate and navigate the tax world, right? That's what I'm hearing.
I think that it's fun to, you talk about the gray areas. I think that one of the things that we know, at least as Americans, is you can't go run off and hide from the IRS. Like they are going to come and find you. And so if you fall into that gray area or you become U.S. Tax person because you broke the residence rule, like the IRS they're going to come out and find you. There's things out there like FATCA and the CRS. There's a lot of information sharing that goes back and forth between all the jurisdictions, and somebody who thinks they may not have this income tax or estate tax liability that's sitting with them might be quite surprised if they're sitting at a cafe in Belgium and suddenly get a call from Uncle Sam say, "Hey, show me the money," right? I mean, that's how it works here. They're gonna come and get you.
Yeah, I think that's one of my favorite questions on the estate, U.S. clients, by the way, who ask me all the time, well, how can I not pay the estate tax? I'm like, yeah, probably not. That's not how
Yeah,
this works. There's still going to
it's
be some
coming.
paying, some way or another. There's going to be some payment of it. But yeah, no, that's interesting. So in talking about intent, because I think this is probably where a lot of that gray happens too, right? Is that intent part of things. So either Robert or Steve, what are some of those accidental pitfalls? Like, what are some of the common scenarios that lead to this incidental or accidental U.S. taxpayer status?
Well, it can be sometimes quite tragic, like the example of a very wealthy person from Mexico travels to the United States to seek cancer treatment at, say, MD Anderson Cancer Center down the street from Steve, and then dies while they're in treatment. So in that situation, oftentimes we think there's an exception. If somebody's here, they're stuck here for medical purposes, we can exclude those days and they won't fall under the substantial presence test. But unfortunately, that test doesn't apply if you actually travel to the United States for treatment. And because the United States has some of the best medical facilities in the world, of course, we do have people who travel here, people of means especially, who will travel to the United States to seek treatment. In that kind of situation, you have to look very carefully at the circumstances of their life while they're in the United States to answer that domicile question and what were their intent. Try to determine, was their intent really just to seek treatment and then go right back to their home country, or had they put down some other roots here? And that's one of the things that Steve would have to deal with in that kind of situation. From an income tax standpoint, they could become very clearly tax resident under the U.S. rules, but maybe they're from a country where we have a tax treaty, and we can look at the tax treaty to see if there's a tiebreaker provision that might help. It usually comes down to a very facts and circumstances analysis either way.
There's an exception if you get sick when you're in the United States from the substantial presence test. So if you can strategically time your terrible illness, then you can at least stay outside the U.S. income tax net temporarily.
So you'd be like, I come to the United States for fun. Oh, all of a sudden my arteries are clogged. So weird. Yeah, absolutely. Now I need to stay here for some health
I'll take a different one just to turn it on a more positive note, and for these poor sick people come to the United States and falling trap of the 183-day rules. I know that we're talking about substantial presence tests, but there's also these circumstances where people come to the United States to go on vacation to like Disney World or whatever, right? Turns out they were pregnant, mom goes into labor early. Suddenly she's had a baby there in Orlando, and the kid now has a social security number, was wrapped in a nice 1040 onesie and said, all right, we'll see you when you're 18, right?
That's interesting. I mean, it's so crazy. These, especially the medical, that's not something that I was aware of before. Coming here to the United States for care, and your intent was to come. So it goes back to that intent situation.
And Kris is exactly right that the United States is one of the few countries with birthright citizenship. So simply the act of being born in the United States will give you U.S. citizenship. And there's many young children who have dual citizenship, and that's a decision to make when they turn 18, whether they retain or give up their U.S. citizenship. And as long as you're a U.S. citizen, even if you're a minor, you are a U.S. taxpayer. So if there are kids with affluent families who are given assets even when they're underage, perhaps in trust, perhaps as a parent-controlled account, they can have U.S. tax obligations and reporting requirements, even though they're under 18 and don't even live in the United States, if they have that U.S. citizenship.
Yeah, that's crazy. The IRS going to get them one way or another, right? They're going to find it. To your point, Kris, there's no hiding it. So, all of these terrible situations, but your expertise, Steve and Robert, is in protecting clients from these type of situations, ensuring that they're prepared for that. So let's talk about some of those strategies to avoid these pitfalls. And Robert, if we can start with you. So here, in the Dallas area, we have a lot of non-citizen clients who, many of them are coming from Mexico. And one of the things to do is buy real estate in the United States, right? It's part of that American dream that everybody talks about. So many of them invest in real estate. In general, what strategies can non-citizens use to minimize potentially hefty U.S. tax liabilities, and also specifically when it comes to investments in real estate?
Thanks, Celeste. Yes, absolutely. foreign investment in real estate is very big. Sometimes the countries change in terms of which country is the biggest source of funds from year to year, but we do consistently see a pattern of people from foreign countries invest in U.S. real estate because the U.S. is seen as the strongest economy in the world, a safe haven with good rule of law, and a very secure place to park money. And real estate is one of the traditionally strongest industries in the United States. So certainly we do see a lot of these kinds of situations. When you're a non-resident person investing in U.S. real estate, there's one key question is going to be, is that property going to produce income? Mm-hmm. If someone's just buying a vacation house and they're only ever going to use it personally, then there's a lot of estate planning that needs to happen. That's very much in Steve's world. But the income tax side, if there's no income, there's really nothing to do. If that property is a rental property, as they usually tend to be, or even a vacation rental, then there is going to be income. There will be an income tax filing requirement. There's going to be income tax to pay, or at least a net income or loss to report. And sometimes the estate planning and the income tax planning do work somewhat at cross purposes, because the most efficient structure from an estate planning standpoint might not be the most tax efficient structure from an income tax standpoint, depending on the situation of that taxpayer and their home country's tax system. So there's numerous cases like Canadians investing in U.S. real property through an LLC, generally not a favorable structure, but other countries might be okay with an LLC. Canadians investing through a limited partnership might be a much more efficient structure for them from an income tax standpoint, but it might not give the estate tax protection that someone wants. So you have to work out a lot of these kinks when planning with a client, and it's very case by case. But some of the common planning structures, or some of the common structures for owning real estate in the United States, would include using a corporation, typically a foreign corporation combined with domestic corporation, what we call a double blocker corporation, because that can give you some income tax advantages and estate tax protection. Sometimes we will see partnership structures because that'll be a much more optimal income tax perspective, and either because of treaties or for other reasons, the client is comfortable with the risk from an estate tax perspective. We'll also see trusts. Trusts are probably one of the most interesting ways of owning U.S. real estate because it can be the marriage of both tax efficiency from income tax and estate tax protection if done well. But trusts are complex, as Steve can speak to, and cross-border trusts even more so. So it depends on the size of the investment. It depends on the amount of income that's expected. It depends on the investment strategy. Is this a rental long-term hold strategy? Is this going to be a quick turnaround type opportunistic strategy? All of those variables feed into the planning and analysis when working with a client on foreign-owned real estate.
That makes sense. Steve?
I might weigh in and talk about blockers for a moment. I think Robert covered most of it, but specifically when you're picking what type of estate tax blocker you want, you got to be very careful. So just to back up a little bit, 40,000-foot view, the reason why you need an estate tax blocker is because if you're a non-US person and you directly hold US assets at your death, then those assets are subject to US estate taxation. You only have a $60,000 exemption for those assets. And so for most people who are investing in the US, particularly in real estate, clearly a US asset, everything above $60,000, if you die holding that asset outright, is taxed at 40%. So
there's not much real estate you could buy for less than $60,000.
I was going to say, where is that real estate? I need to go buy it.
So the typical strategy is to get one of these blockers in place, right? And so as advisors, if you can get in there nice and early and say, hey, before you buy that piece of property, let's sort of set a blocker up and have the blocker buy the piece of property, then that's the optimal situation. But those blockers take many different forms and shapes. So specifically, corporations or foreign corporations are like the bread and butter of estate tax blockers, because when the non-US person then dies, they don't own a piece of the actual real estate in the US. They die owning shares of a non-US company. That non-US company is not US cited for estate tax purposes, and so there's really no US estate taxation on that. With a trust, on the other hand, or even something like a limited partnership, it's a bit more of a gray area. So let's just talk about each of those quickly. I just want to highlight some issues that can arise. Limited partnership or a partnership of some sort. So let's say you wanted to come through a Canadian limited partnership, or BVI limited partnership. And that partnership's going to own real estate in Dallas. The partnership, generally speaking, is under most laws is pass through. It's transparent for a state for tax purposes, both in the US and usually in the home jurisdiction. So it's a gray area, and there's no clarity from the Internal Revenue Service as to whether or not those non-US partnerships act as effective US estate tax blockers. Now, a lot of people use them. You can make elections to have those treated as corporations for US estate tax purposes, but the fact still remains that a partnership is just really a collection of individuals who agree to do business together. It doesn't necessarily have a legal personality. A corporation has a legal personality. Partnership, kind of a gray area. Now with trusts, those sometimes will have a legal personality, if you like, especially in a non-grantor trust situation. But the trick with having a trust be a blocker for a non-US person is to be exceptionally careful with how you draft that trust agreement. And as all of us know, the biggest challenge for our clients when they are setting up trust structures, or frankly planning structures of any sort, is surrendering control. And so you need to have a conversation with your client sometimes and say, yes, we can use a trust that may make more sense for your Australian tax purposes than having Texas LLC or whatever it might be, but you got to give up this control, this control, this control. Oh, and you want to put your wife in there? Well, she has to be maybe one of 4 people that have control, or one of 3 people that has control. And so it becomes this a bit of a game of whack-a-mole to try and make sure that it works for tax purposes and then also satisfying the client's objectives for estate planning purposes.
Oh, that's complex. Just thinking about it, just all the things that they have to think about in advance. And you said 2 things that I really want to expand on, because first of all, a lot of the non-citizen clients that we work with, and Kris can attest to this too, many of them come to us not even knowing that they have estate tax exposure. They don't even know what an estate tax is, because in their country that might not be something that is effective there. So understanding then that their exemption is only, and to reiterate, because I would say 99% of the clients that come to us that are non-citizen clients don't know their exemption is only $60,000. From my perspective, I would just say it that way. I don't think the IRS has any intention of ever changing that, because there's no real reason for them to do it. Whereas a U.S. citizen or somebody that, from an estate tax perspective, consider U.S. citizen, their exemption individually is over $13 million. So I think that's really important to reiterate to our audience and for them to know the difference, because most of the time people don't know. The other thing you mentioned was before buying. True story. I had a client a few years ago, it must have been 6-7 years ago. He and his wife came to Texas. They were just on vacation. They had previously bought some life insurance, but they went out to a property and his wife fell in love with it. They had enough money. They just bought it. It was probably like a $15 million property. They decided they love the hill country in San Antonio and were just going to buy it. Did not do any planning before. So that happens, right? There's those impulse buys that happen as well. Mm-hmm. So doing the preparation before committing and making sure it's structured properly, I'm sure you all can mention, it makes it much cleaner on the back end, right? If you could do it in advance.
So if I may, to kind of piggyback on that comment and to emphasize the importance of this is not you don't try this at home, kids. This is a don't try it at home, kids kind of situation. We have clients that will do it halfway, or they'll buy the property and then they want to do some planning after the fact, or they buy a property through a U.S. corporation and then they realize that the U.S. corporation doesn't protect them from estate tax. It's still subject to estate tax. So they want to get into a foreign corporation. Well, there's a law, an anti-inversion rule, that's designed to prevent big companies from flipping from U.S. taxpayers to foreign corporations, but the rule doesn't only apply to big companies. So if you take a U.S. corporation and then put it into a foreign corporation, the law will say that foreign corporation now becomes a U.S. corporation for all purposes under the tax code. So that attempt at restructuring will give you additional headache without solving any of your tax problems, because now you have a foreign corporation that's treated just like a U.S. corporation and your planning is moot. So it is very important to do the homework on the front end. and to make sure you're hiring good professionals, because there are so many traps for the unwary that are very easy to step on and cause big problems.
I think that there's another point here. I know we're really talking about foreigners coming into the United States, but even on the outbound side, for those individuals who are looking and acquiring things outside of the U.S. if they're U.S. citizens, that can also be problematic. You should definitely seek counsel before you do something like that.
Yes.
The last thing that any of us want to see is somebody coming to us saying, "Oh, by the way, I bought a vineyard in France." Oh boy,
So funnily you mentioned that. I had a client who was very close to buying a chateau in France, and I think the original intention was that they would buy the chateau and then 3 generations of the same family would go and live in the chateau.
Ah.
It didn't happen, but if they had have gone through with it, they would have had enormous French tax problems to deal with because the French have a pretty high level of taxation on inheritance. And so when they did eventually buy a couple of apartments in Paris instead, they were able to do that in a way that was somewhat copacetic with US taxation and French taxation. But it was a bit of a lift with French counsel to get them there. So they did it the right way around, thankfully.
And every country's so different, right? But Kris, if our
Yeah.
client said that first, I'd be like, okay, well, invite me. Then I'd be like, and let me introduce
right.
you to my friends Steve and Robert because you need them because you've done
Definitely.
this the very wrong way. But yeah, I mean, it happens. We have so many clients that just buy things on impulse at times for different reasons, emotional reasons sometimes, but it happens. So, Steve, what about just business ownership for non-citizens? How does that complicate things tax-wise? I know we talked about it if it's property and it's for income, but now what about just having a business in the United States?
Yeah, absolutely. So I think fundamentally the key thing is that let's say you're someone in London, you've got a great podcast business, actually, funnily enough, which I have a client in London who has a podcast business, and they want to open a subsidiary podcast entity or something like that over here in the US. Well, underlying that business is probably going to be some kind of a US structure. In fact, maybe podcast isn't a great example. Let's say it's something like real estate investment, right? Where you really do need an actual entity in the country where you're going to start investing in US real estate. That US entity is probably going to have some kind of exposure to US estate taxation at that person's death. So as just a baseline question, you need to think, okay, how am I going to run my business operations in the US? And how does that work for my own personal estate tax exposure? I think the other thing that I've seen here specifically with business owners who are starting more modest business operations here, or maybe have modest legacy business operations here. So, for example, a client who has inherited maybe some operating oil and gas companies, or like a oil and gas limited partnership that makes periodic investments here in Texas. So when I've had this situation arise before, oftentimes they say, oh, well, I can't get rid of my US entity, or I can't get rid of my US accounts because that's how I run my business. But I think in reality, especially in the modern era, if you don't have massive business operations in the US, I don't know that you necessarily need to have a massive operating account over here in the US to accompany that. And let me just explain briefly why that's a problem to have an account. So we've talked about the structure, right? There's nothing you can really do. If you have to have an LLC holding your business interests here, then let's hope you get a blocker in ahead of it so that you can have some kind of estate tax blocker. But if you have an account, let's say that's with for cash flow purposes with that particular business, that account is going to create two problems. Firstly, if you have US cash in it's a brokerage account, then that becomes a US citus asset for estate tax purposes. And if you have cash in a brokerage account, but then also if you have accounts over here and then you die and you're a non-US resident, then you have to navigate the probate process to get that account unwound when you die. And that is an enormous headache. And note, I just mentioned non-US resident, not non-US citizen. So for somebody that is a US citizen but lives in London or Paris or wherever, and they keep an account here, they can have specific probate problems that arise for them, even though they're still a US citizen, because they are a non-US resident. And so just to zoom out for a second, I think for business owners, the question is, okay, what have you got? Do you really need that? And what accounts do you have? And do you really need those accounts? Or is there some way around this headache that you're landing yourself in?
That's so, I mean, everybody comes here gets a bank account, right? You just think, okay, I have a business. I need a business account.
Right.
So that's incredibly interesting to know. You really have to think even about that level of planning, how that could impact. I don't know, Robert, if you had any other insights specifically to business ownership.
I think with businesses, so obviously income tax is usually issue number one for many businesses that are starting in the United States, expanding to the United States. So understand, and sometimes clients are moving to the United States to help make their business successful, be it temporarily or long term. So oftentimes you find ourselves working with the business attorneys, the immigration attorneys, and the business owners themselves to figure out what is the best plan from an operational standpoint, what's maybe required in order to qualify for the visa that they need to be able to travel to and from the United States. There may be requirements imposed by the immigration laws that actually impact the tax and accounting structure of the business. And ultimately, can we find a structure that's going to optimize for income taxes and optimize for operational efficiency? Because at the end of the day, the business needs to make money. The business needs to be paid by their customers. So we're also looking at, well, what's the easiest way to get you paid by your customer? What's going to make it the easiest for you to deliver your service or provide your product to your customers in the United States? So it's fun because it's a conversation not just about the accounting and tax particulars, but also just really rolling up your sleeves and getting involved with the business and understanding what is going to make this business successful and building a structure around that.
I had a client in Mexico. I guess a lot of my non-citizen clients are Mexican just because of our proximity to them. But he had a very successful furniture company. It was a lot of like woodwork, beautiful furniture. So he expanded into San Antonio and other parts and kept growing. And when I was introduced to him, it was because he was shocked to find out that he had an estate tax issue because he primarily lived in Mexico and his family was in Mexico. Sure, he had businesses in the United States, but I'm sure Steve and Robert, he did all the things wrong. He didn't have the right direction up front to set things properly. So I can see that it's easy to fall into those traps. I didn't know you all back then, so this was prior to having these experts in our toolbox to be able to reach out to. This is many years ago.
Hard. Even for someone who's very well educated, very successful in their business, knows how to navigate everything in their home country system. The U.S. is different. The U.S. market is different. The U.S. laws are different. Another thing that's surprising for many clients is our state and local income taxation. Sometimes also death taxes at the state level. There may be estate tax at a state level, but typically we're dealing with state and local income taxes, sales tax, which is very different in many ways from VAT, value-added tax, that clients may be used to in their home countries. So it's also kind of opening their eyes to the additional complexity of there's 50 states plus the District of Columbia. They all have the right to tax things the way they want to. And they've come up with diverse ways of taxing businesses, and those have to be planned for too.
I like that. Diverse ways of taxing businesses. How are we going to make back our debt? Is it really the question, right? How can we tax people? So before getting into that, and the IRS probably sends me some nasty notes, let's talk about, we've already touched on estate planning, quite a bit, but let's just delve a little deeper into that. In our world, and by our, I mean Kris and in my world, that's where really we see a lot of the issues that clients are facing. So Steve, what foundational elements should non-citizens consider when they have assets or even just family members in the United States?
Yeah, so this is something that we're seeing, I think, more of as we go through this generational transfer of wealth. So as the baby boomers depart and then they transfer their assets down to the millennials or Gen Z or whomever it might be, a lot of those younger generations are finding the US increasingly more attractive. And so oftentimes what I've seen happen is kid grows up overseas, non-US parents, and then moves to New York to pursue, the Broadway dream, or goes to LA and wants to make it big in Hollywood. The problems that can arise when the parents are trying to figure out how do we transfer wealth to these people who are US, can be really, really problematic. And I think that the trickiest thing for the parents is to figure out what does the next 5, 10, 15, 20 years look like? I mean, I think all of us on this call have kids. I have no idea what my kids are going to be doing in 5 years' time. If I can
Just
keep
keep
them
them out of
alive,
prison,
that's
right?
primary
That's
goal.
yeah, yeah.
But in reality, for people with money, or for people that have kids over here who may not have kids yet, may not have careers yet, it's a really big question mark. So the big question is, how do you plan for that, right? The way that I've tried to break this down for clients before when they're transferring wealth to these family members is to try and think about this in time frames. So, and we can do this in domestic estate planning too, right? So, okay, your kid's 20, they're in LA renting, maybe runner on a film, something like that. At 25, what do you think their life's going to look like, right? They might have got a job, or let's take a college example. 20, come over here for college. 25, they probably graduated undergrad. Okay. 30, people are probably maybe got married, or maybe are starting to think about having a family. 35, maybe that's deemed some age of maturity. I'm not sure. But you can kind of spread life out in these increments, and then you marry that with the tax planning. So, for example, if you have somebody that has been here for a year and they may be US tax resident, they're not going to have the same tax issues as somebody that's been here for 5 years. So somebody's been here for 1 year, they're on a temporary visa, maybe their substantial presence test is suspended. So planning for them in that moment is going to look really different than in 5 years' time, when they're definitely going to be an income tax resident because they've triggered the substantial presence test, or maybe they've got a green card or something like that. So that's sort of step two. And then the next step might be, well, they've been here for 10 years and now they're subject to something nasty called the exit tax if they ever want to leave. And so marrying life timelines with tax timelines, I think, is the best way to try and approach this and figure out, okay, what are we going to do and how do we build flexibility into our plan?
So you get taxed when you come in, you get taxed if you try to leave. So there's taxes in every direction. That's interesting.
There's also taxes when you're trying not to do anything but do the right thing, right? So if you have something like mom and dad set up a foreign trust that now benefits a kid who's been here in the United States, suddenly you might be facing things like D&I issues if that trust becomes a foreign non-grantor trust. All of a sudden you have this beneficiary who's a U.S. person in the trust. Like, there's all kinds of wild implications that can happen from a tax and estate tax planning perspective for folks like that.
Normally, the best thing you can do when you're advising families like that is to help them build in as much flexibility as possible. And so, to give you an example of what that might look like, depending on the family circumstances, if somebody is non-US and they're setting up a trust structure for their US kid, and they don't know if that US kid's going to be here long term, it might be better to set up something offshore. And the reason for that is because it is a lot easier to enter the US tax system than it is to exit the US tax system. So if you have a non-US trust that has all of those D&I throwback tax issues that quite esoteric but can be quite punitive because the parents have died, then at least you can bring it into the US. But if you set up a US trust, like a South Dakota trust or something like that for these kids, and then they I think I'm done with living in California, I want to go back to Germany or wherever, to make that trust follow them to a jurisdiction that's a little bit more tax friendly than the US can be really punitive.
Yeah, that's a good point. Planning for those transitions and coming to the United States for school, for different things, for maybe it's a job opportunity. Just in my neighborhood, so we have SMU here, and they have a big international presence, or they recruit internationally. In my neighborhood, there's 3 different people I can think of who came here for SMU and are still here. So, and it's been probably 20 years. So I'm certain that happens more often than not. And now they have, different types of issues. So Robert, from your perspective on the, the accounting side, on that side of the world, what are some of the planning opportunities that you find most effective when it comes specifically, from an estate tax perspective for your non-citizen clients?
An important thing to point out when thinking about the planning for example, kids who come to the United States and parents are still overseas, that gifts are actually reportable by U.S. persons when they receive more than $100,000 from a foreign person. So even though there's no income taxation of the receipt of gifts, those are tax-free in the United States, there's still a requirement to report the receipt of that gift. And if you miss that report, there's an automatic 5% per month late penalty, up to 25%. And the IRS is extremely good at assessing these late penalties. The form in question is Form 3520 to report foreign gifts. It's also the same form that reports U.S. ownership of a foreign trust, transfers to a foreign trust. It's kind of a kitchen sink form, but a very, very important one in this world of cross-border estate and gift tax planning and compliance. I think from an income tax perspective, we always try to lead with what is the goal, what's the long-term goal, and are they going to stay here or are they going to go back overseas? And of course, oftentimes the answer is, well, I don't know. So we're looking at how do we preserve as much optionality in the structure as we possibly can. We look at things like, okay, if we want to flip this structure to a foreign structure in the future, can we do that? Or are we going to cut off certain avenues of future planning if we use this type of entity or another type of entity? For example, setting up a corporation or a partnership that might be restricted from reverting to a foreign corporation in the future. So I think it's important to have a really long conversation with the client, truly get to understand the different members of their family, the different goals, why they're here. And sometimes I honestly will tell clients, I think you should go home for a little while so we can keep your days under the limit and give us some more time to plan. Because if you move here and straight away start staying in the U.S. full time, you could really create some bad tax problems. If you go home and give us some more time, we can put things in a better structure for you.
Have some of your home cooked meals, and maybe you want to stay there, and it might be easier for you long term, right? So, yeah.
And don't try to game it either, because they will figure it out. If you're not keeping a good log, they will try to do their best to wrap you into the code.
Yeah, I absolutely love helping foreign clients come to the United States and be successful here. I get a lot of satisfaction from helping immigrants. At the same time, I want to be very realistic with them that there's going to be tax obligations and headaches, and some of them are soluble. Some of them are not very easy to solve. And they have to think long and hard before they commit to coming to the United States.
Yeah, the American dream comes with caveats. There's a lot of little stars, disclosures at the bottom, right?
Absolutely.
One sort of related note I wanted to make about getting, on a sort of a positive side of things, if I may, inheritances from non-US people, yes, you have to report them on a 3520, but if you plan them correctly, they can be extremely tax advantaged. So in my example with the California resident child and non-US parents, if they set up a structure, even if it's a US structure, and then they fund it with a bunch of non-US assets, those assets, if they're kept in the right type of trust structure, can be outside their children's estate in perpetuity. There is no estate and GST taxation if you're a non-US person, you're funding a structure with non-US assets. So it is a question of timing, but if you can get in there early enough and say to them, hey, especially if you're talking to the kid, this can be a little awkward, but you can go and say, hey, why don't you go ask your parents what you're going to get, how you're going to receive it, and then if they give you the answer, you might be able to say, well, hey, maybe we could put that into some kind of nice trust structure because it's going to save me tens of millions of dollars at my death or something like that.
Their parents are going to say you can get nothing until you prove your worth of stay in college. But yeah, I know that absolutely makes sense. It's knowing what that looks like and putting it in the right structure. So talking about structures, a question that comes up a lot is, do I need a U.S. will if I'm going to be here sometime or a lot of time, a little bit of time? Steve, what's your recommendation on U.S. wills for non-citizens?
Yeah. It's a great question, and it comes up all the time. So obviously it's driven by circumstance or case by case, should I say. I think there are some advantages and disadvantages. The advantages of having a US will, if you have US assets, are that you can have a bit of better certainty with probate. So let's say, to take your example from earlier, Celeste, the people that came here on holiday then bought a property in the Hill Country in Texas. Well, that property is, when they die, is almost certainly going to need to be subject to some kind of probate proceeding in Texas. So knowing that, you could say, okay, client, I suggest you have a US will here because we know we're going to have to take a will of some sort and get some kind of probate proceeding in Texas in order to pass title to that asset to your children or to whoever it's going to. On the other hand, there can be some pretty big pitfalls with having more than one will. And this isn't really specific to inbound people having a US will. This would apply equally to people who have that chateau in France I was talking about. The biggest problem, I think, is there can be a real risk of conflicting provisions between wills, 2 wills, 3 wills, 4 wills. And it takes a lot of really careful drafting to make sure that a US will and a non-US will play nicely together. The problem is compounded if one will says one thing about how a piece of property is going to be devised, and the other will says something totally different, but they don't necessarily invalidate each other. And actually, oftentimes, if you know there's another will, you say, oh, this revokes all wills in the US except my English will or except my French will. And then the French will says that revokes everything except for this, but then they purport to govern the same piece of property. So that can cause real issues. The other fairly obvious problem is with the cost of having additional testamentary documents, again, whether that's inbound or outbound. Some of the richest people in the world like to still shop on the right side of the menu, and I totally understand that. But ultimately, they may be a little bit reticent to want to go hire another lawyer in another country to get another will in place for them just because they have an investment property or a vacation home in Florida. I totally understand that. I think the third thing and the last sort of big picture disadvantage is I'm not sure that there's necessarily a cost advantage to having a US document in place versus having a non-US document in place. There's some caveats to that though. So to zoom out for a second, if you're in a place like Texas or a lot of different states, you can have probate here with either a Texas document or most often some kind of foreign will. So I could have my UK will, I could bring it to Texas, and I can actually do a direct probate of that UK will under Texas law. The cost to do to probate a Texas will versus the cost to probate a UK will is actually not that much greater. You do have to find somebody that kind of can do cross-border probate administration, but it's not going to cost you that much more. But the biggest caveat to that is you've got to be thoughtful about where your other testamentary document is coming from. So in my example, it's nice and easy because a UK will written in English based on common law principles, you have the same kind of concepts of an executor or an estate. And so that translates pretty nicely, for want of a better expression, into a Texas probate. But if you had something like a French will, and you were trying to probate that in a Texas court, I think you could run into some really significant issues. Not only is it in French, most likely, but also the French legal system doesn't have the similar concepts that we do. It's a civil law system, so they don't have concepts of an estate or an executor. And so I think being really thoughtful about where your other document is can actually lead you pretty swiftly to the answer of whether or not you need a US document in place too.
Once again, you needing an expert there, because how will you know if that U.S. document is, non-U.S. document is better than the U.S. document? Because to your point, once again, every country is different in how they manage it. So recently we were working with a client that has real estate in the United States and in Mexico for income. Both of them are rental properties. And in talking to one of their Mexican advisors, it was just so interesting to see how much they were not recommending a trust. And in the United States, trusts are like cornerstone planning for us, right? We talk about no probate. It makes it so much easier. So many things, so many reasons why trusts are great. So is this the same, or why isn't this the same, Steve, in an international setting? Like in that example, it didn't seem like it made a difference for there to be a trust or not. So can you explain more of trust, talking about another, kind of structure or entity, trust in an international setting?
Yeah, absolutely. So I think some people might think, well, if you're in a common law system, wherever you are in the world, then maybe the trust makes sense. So just to a little bit of edification for everyone who doesn't know this, the trust was created during the Crusade era in England back thousands of years ago, or 1,000 years ago, whenever that really begun. I think at the 800s, let's call it that. And the original thinking behind it was that these knights would go off to the Holy Land, they'd go on their crusades, but they needed to leave somebody at home in charge of their property, basically for their wives and for their children, because the wives and the children weren't entitled to own property. Okay, so it has been around. The concept of a trust has been around for centuries, and particularly it is a unique common law instrument. So you might think, if you're in the UK and you have a flat in London, okay, maybe let's think about setting up a London trust to hold that, sorry, a UK trust to hold that London piece of property. But actually, a lot of common law jurisdictions now, the UK included, are starting to punitively tax trust structures, with the idea being that they are some kind of tax avoidance structure. And so that's increasingly this direction that we're heading in. It's quite foreign for us folks over here in the US because we use trust all the time. A lot of common law jurisdictions overseas don't like that. So to give you an example of what it means to set up a lifetime trust in the UK right now, there is a tax on the way in. So when you settle the assets, there's a tax. There's a tax every 10 years when you have assets in that trust. And there's a tax when you try and take assets out of that trust, which is crazy because we created the trust and now we don't want people to use the trust.
Yeah.
That's happening in the common law sphere. Now, in the civil law sphere, there has always been a bit of a hostility towards the common law trust, because frankly, they don't understand it from a conceptual standpoint. I mentioned this earlier. The French legal system, for example, I feel like I'm picking on the French here. I'm not doing that deliberately just because
We
I'm
like
English.
French people. Don't get mad at us.
No,
Yeah.
lovely country. But they don't have a concept of the separation of legal and beneficial title. So conceptually, under French law, it's always been tricky for them to understand what a trust is. So to give you an example of some of the challenges that can bring up in a civil law country like France, instead of seeing it as a regular estate planning vehicle, they actually tax it as if it were a completely like a third person, which for French inheritance tax purposes means that it gets taxed at 60%. So if you're and I've got US clients who live in France, right? So they are trying to figure out how do they give assets to their kids. First thing we do is say, oh, let's have a revocable trust. Let's have a trust of some sort. But actually what that does is, instead of taxing them under French law at 45% when they give assets to their kids, or in the US, you'd give it to a trust for the kids, by interposing a trust between you and your children, you've subjected your trust to 60% taxation, because the French don't recognize the trust and they see it as a third party. And so they think it's just a completely unrelated person and it's taxed at 60%. So you're going to be very careful how you employ trusts if you're working in any kind of civil law country, because oftentimes they are taxed extremely punitively.
Just to dive a little deeper, from your perspective, Robert, on the trust side, I know, once again, being in Dallas, there's a lot of cross-border planning here. How have you seen, or the best use or worst use, or when doesn't it work, as far as protecting assets across borders, cross-border inheritance, outbound and inbound? Like, what's been your perspective on trust planning?
I think what's important to keep in mind with U.S. people and trusts is that the U.S. taxation system of trusts makes it very easy to accidentally get a foreign trust in these cross-border situations. And having an accidental foreign trust is a very bad answer indeed, because then you have a trust that was intended to be a U.S. domestic trust, and because of a power holder or a trustee becoming a foreign person or for some other reason, it now definitionally becomes a foreign trust. that means that you have to file more tax returns. You have potentially significant penalties if those tax returns are missed. You have potentially much more punitive taxation of the income to beneficiaries. For example, if it becomes a foreign non-grantor trust. As a foreign grantor trust, all of the income gets taxed immediately to the settlor of the trust, or the grantor of that trust. So the U.S. person has to pay tax on all the earnings of that trust. There's a whole bunch of things that can happen. You don't want those happening by accident. So foreign trusts can be a very useful tool for estate planning and for asset protection, but they have to be used very carefully and very wisely, because it's certainly not going to work for tax evasion or avoidance purposes. I think with clients in the U.S. who have foreign trust structures from their parents or different things like that, like sometimes we have the flip side of what Steve was describing in terms of foreign countries not understanding U.S. trusts. Our law doesn't understand many foreign structures in civil law countries, like a foundation or a stichting in Dutch, which is a very common structure in many countries. Well, we don't have that concept here. A family foundation for us means a nonprofit philanthropic organization. Mm-hmm. But in many countries, a family foundation means an estate planning tool. And it's completely private and has no charitable purpose whatsoever. So as a tax preparer, we're stuck in a position of trying to understand how to interpret this creature, this legal creature, under a U.S. tax lens. Is it a trust? Is it a corporation? Is it something else? What is it? And recommend to the client the appropriate tax planning and compliance approach. Oftentimes in those cases, we will lean heavily on local counsel in the country in question. Our firm is a member of an international association for that purpose, so we can find the experts in the other countries who speak English and can help us interpret these things. We'll lean heavily on Steve and his firm and his contacts in the legal world to try to understand, okay, what is this creature in its home country? How is this creature treated from a U.S. perspective? What are the potential options so that we can properly advise the client?
Absolutely. So the answer is, do I need a U.S. will? It depends. Do I need a foreign trust? It depends. So, I mean, and that's really the truth, right? It's just going to depend on their specific situation as far as what makes sense.
Accounting and tax questions is always, it depends.
Yeah, there you go. Yeah, absolutely.
I might just say though, when the answer is it depends, that's not always a bad thing, right? So because it indicates flexibility, I think. And ultimately, to take Robert's example, if you're trying to classify for US tax purposes a non-US structure and you've got a little bit of flexibility, all you're doing is taking a position, right? So if you have a defensible position that is this type of structure and not this type of structure, then you can plan better for your client and say, we can take this position, and that means that, you didn't have those returns that you thought might be due. Ultimately, it comes down to, whenever it's scrutinized. But I think it's better sometimes to be in that gray area, because then you can make sure the structure fits the purpose that it was intended for.
Absolutely. I think if you're a good advisor, your response should be, it depends. But people come to us, even in our world, in life insurance space, right? People will call and say, Celeste, I need life insurance. I'm like, great. They're like, what do I need? I'm like, it depends, because I don't know anything about you yet, right? So I think just being a good advisor. Kris, you have something to share?
Yeah, completely. And to both of these points, like, you have to think, bilaterally between all of the jurisdictions that are at play, where mom and dad are, where their kids are going to be, and again, where they're living, as you all pointed out. Like in the insurance side, Celeste, as you said, when internationals come to us, we have, 3 different ways to look at it. Do we get something in your home jurisdiction? Do we get something offshore on the life insurance side? Or do we look at the United States as where you should be obtaining your life insurance? Everybody knows, generally speaking, the U.S. has the best pricing when it comes to life insurance. So this is like the best place to get it if you can qualify for it. But that can also run afoul another way. So just using a simple example, if a Canadian comes to the United States and they get a US-based policy, that might be okay, but everybody has to realize that, just like what you're pointing out on the trust and estate side and the income tax side, Canada has their own rules about life insurance as well. So what somebody might acquire here in the United States may not actually be valid in Canada. And now all of a sudden that life insurance policy that's supposed to be this nice, non-taxable shelter is suddenly taxable, right? So again, you have to get that advice on both sides of the border.
Absolutely.
I was working with this Asian family, and mom and dad had a huge operating company in mainland China. Fast forward, mom and dad passed away, didn't do any estate planning, and every single one of their kids were U.S. citizens because they had them born here in the United States. And so suddenly these kids were thrust with a ton of wealth, good for them. However, it also came with a massive problem in that they now had this corporation which was domiciled in a foreign place. They couldn't liquidate it. They can't do anything about it. And they have this massive U.S. estate tax bill that's looming. And so, from our perspective, we were pretty limited in what we could try to figure out to do because it seemed like all the tax laws and like what you could do structure-wise was very ambiguous. And so like insurance became, one of the primary things that helped solve this problem. Is like, yeah, your first thing to fight this is going to be life insurance, and then we're going to spend a ton of time trying to figure out what to do with this structurally.
Yeah, and we all have stories.
It's important to point out that sometimes, we've talked about entity structures, trust structures, things like that. Sometimes the right answer is life insurance, because if you're comparing different planning options, there's a cost. It could be a tax cost, it could be administrative cost, it could be legal fees. There's going to be a cost to setting up a structure. If those costs are not worth it, or if administratively it's going to be too difficult to get the right structure, and life insurance is available and affordable that can meet the need to pay the estate tax in the event, especially if it's a temporary type situation, like someone who's in the United States temporarily has valuable assets or is going to have U.S. assets for a temporary time and then expects to sell them in a few years, life insurance can be a great answer. And I oftentimes will tell clients, your options are, we can plan the structure, we can try to predict every possible outcome, or you can do what's operationally best and get life insurance to cover the risk.
And then they call us, right?
Right.
Shameless
Exactly.
plug. Yeah, no, thank you very much. I appreciate that, Robert. So kind of just shifting gears before we kind of wrap up, we always like to touch on some of the misconceptions that pop culture provides. So as we all know, Hollywood loves to glamorize tax evasion and secret Swiss bank accounts because it sounds super cool, I guess, sexy. But how much of that is actually reality and how much of it is fiction, especially nowadays with all of the new regulations?
Yes, I think it depends on what time frame you're talking about. I think the funny thing about this is sort of offshore accounts and having assets outside the United States in Switzerland or Panama or the Cayman Islands. It's both more mundane and common than you might think, and at the same time, not what you would expect. So there are lots of legitimate reasons why you would put assets in a tax haven country. And those reasons are typically tax neutrality, trying to build something for investors where the structure is not going to impose taxes, but the investors will pay taxes in their home countries at their home country rates. That could be a very useful purpose for a zero tax jurisdiction. And everything is done with full transparency, full tax reporting, and nobody is evading any taxes. On the other hand, there's many clients who had structures set up in the 90s or the early 2000s that were funneling money into offshore accounts. In many cases, those advisors who set up those structures did not tell their clients about the reporting requirements or did not do a good job making sure that their clients were well informed. And when the Swiss bank scandal broke in 2009, a lot of clients woke up and realized that whether for nefarious reasons or for perfectly ordinary reasons, they had accounts that needed to be reported. And we helped many, many clients with voluntary disclosures to the IRS and getting the filings up to date, paying penalties, sometimes paying reduced penalties under one of the IRS programs. But it was a big deal to get people tax transparent. Now we live in a world that is extremely transparent and getting more so every day. Mm-hmm. Even clients who want to, say, come to the United States because they see the U.S. as a tax haven and they can hide assets in the United States, well, even that is coming to an end because the Corporate Transparency Act is going to blow open a lot of these Delaware structures and other things that have been chosen for opacity, and it's going to create much more transparency.
Yeah, absolutely. So it depends.
Echo that, yeah, it depends. To echo that, Robert, I completely agree. I really don't think there's any such thing as financial privacy anymore, for better or for worse, depending on which side you fall on. And I think there's still a compelling argument that the US is actually the most financially private country in the world still, funnily enough, even with the Corporate Transparency Act. If you compare that to most of the due diligence and KYC type regimes that apply in most, well, certainly all of the other developed countries in the world, but every other OECD country that is subject to something called the Common Reporting Standard, that's like FATCA on steroids. So I think it's still attractive to put money here for some degree of financial privacy, but ultimately it's all disclosed, it's all transparent, and that's the way it should be.
Yeah.
That we're not doing these types of planning structures to hide money. We're doing them for legitimate planning and tax and estate planning reasons.
Yeah.
And
I will say, in the last 14 years, I have not yet met a Bond villain.
I was going to say, so it's not 1970 where everybody's aspires, James Bond or something like that, putting money away in other countries. So maybe, once again, think about what you're doing before you do it. See if it's a good idea. Well, thank you. Yes, go ahead, sorry, Kris.
Yeah, since we brought up TV and that kind of stuff, one of my biggest complaints, I'm going to go on a rant here just for half a second. One of my biggest complaints in the U.S. is how we talk about and market all the different structures that we have. And so just as an example, we have wings, dings, and nings, which is all the same type of trust. It's just in a different state. While internationally, when you're doing cool, fun international, you get stuff like double Irish Dutch sandwich and then single malts. Like, we got to do better here in the U.S. We got to start naming our structures better. So I want to challenge you, Stephen and Robert, to work with me on how we can come up with better names for all these fun structures that we're part of.
You don't like eyelid, grat, slat?
It's just gross.
Yeah, alphabet soup of...
Everything's an acronym.
Yeah.
Idjit. What? I don't want an idjit.
Yeah, exactly.
On your Hollywood question, Celeste, one of the most contemporaneous things that's going to happen this year is when we have the election, there is going to be an inevitable run for the borders, figuratively and literally speaking, because depending on who wins, the other side, there's always some people that are apoplectic about that happening. And so in election years, we get a lot more calls about people wanting to expatriate, and they want to go to places like Nevis and St. Kitts or something like that. One of these countries that offers, a passport for $500. And be a bit facetious, but and the reality is, for people that actually want to do that, when you start to talk to them about the reality of not only the tax side of expatriating and the exit tax, but also the reality of living in somewhere like Nevis, and how that is going to look for the next 20 years, and the fact that they've given up their privilege to come in and out of the United States, I think that blows that fantasy out of the water for them, unfortunately. But you're educating your clients, so I think that's important. But I think it's an attractive sell for people. But then when you start to get into the weeds a bit, they realize that maybe that's not a great idea.
As I tell my 7-year-old, every action has a consequence, whether it's going to be a good one or a bad one, but every action has a consequence. So very true.
Yeah, it's going to be interesting to see. I agree with that. And then, just what's recently been going on with Canada with them increasing their capital gains tax, right? There's been a bunch of talk about wealthier Canadian families now suddenly wanting to leave Canada, coming to the U.S. or other low tax jurisdictions. So yeah, you're right. It's going to be really interesting to see how the election pans out and what people actually do versus say they're going to do, and then other countries who are going through similar changes.
Always evolving. Well, I know we can talk about this all day long, but I don't know that our podcast viewers or listeners are going to want to listen to 7 hours of international and estate and tax planning. So at some point,
because we need better names for the structures.
Yeah, to make it more interesting. Yeah. Thank you so much, Steve and Robert, for joining us today. We really appreciate it. I've learned, you feel like you know so much about some of these things, but every single time in hearing you guys present or speak, I learned so much. So I hope it's also been eye-opening for our audience. And Kris, thank you. Always great to hear your stories and your insights, because our side of the world, we get to work with some interesting clients and see some interesting things too. So that's a wrap for today. Don't forget to check out our show notes for links to resources. We'll also have our guest contact information so you can continue that planning conversation with them, so you can avoid those pitfalls before they happen. Also, make sure to like, subscribe, and if you like what you've heard, please share this podcast with others. So as always, thank you so much for joining us on another episode of Planning Reimagined, where your wealth journey meets our expert insights. Thanks for listening. Don't forget to like and subscribe, and please be sure to follow on your favorite podcast player. To connect with us, you can email us at hello@robinglenn.com or schedule some time with us via the link in the show notes. You can also find us on Instagram and TikTok at Hello Robin Glenn.